In this lecture, we are going to cover some definitions that we will be using throughout the course. What do we mean when we're using the term juvenile? A juvenile is any person under the legal age of majority. In most states, the legal age of majority is 18. A juvenile offender is a minor who has been found delinquent for a status offense or for committing an act that would constitute a felony or a misdemeanor if it is committed by an adult. A status offense is a non-criminal act that is considered to be a violation of the law only because of the individual's status as a minor. Things such as running away, truancy, or skipping school regularly, curfew violations, and then there's a couple of fuzzy terms, ungovernability and incorrigibility. Right? Here the idea is that the young person is breaking rules at school, breaking rules at home, and they have behavioral issues, but these don't rise to the level of a crime. When dealing with individuals who have committed status offenses, right, the Juvenile Justice Delinquency Prevention Act discourages states from utilizing tactics such as secure detention or placement in a juvenile correctional facility for status offenders. The goal is to try to deal with status offenders in the community because of what we're going to look at later on in the semester, which are collateral consequences involved in detention or the placement in juvenile correctional facilities. A criminal act is an unlawful act that is punishable by the state, and these are divided up into two general categories: misdemeanors and felonies. A misdemeanor is a crime that is punishable by less than 12 months in jail. Right? Misdemeanors typically do not involve significant levels of violence. Here's an example of a misdemeanor offense, right? Petty theft, so stealing less than $1,000, or an item that's valued at less than $1,000. Abuse of school teachers, right? So this is one that would be committed by a juvenile. And abuse of school teachers, right? The individual is upbraiding, insulting, or abusing any teacher of the public schools in the presence and hearing of a pupil. Right? So you can't stand out there and scream at your teachers. Felonies are crimes that typically involve violence and are punishable by imprisonment of more than a year. So we're looking at offenses such as aggravated battery. Aggravated battery causes great bodily harm, or the individual has used a weapon. Rape, grand theft, so theft of items valued at more than $1,000, or theft that's carried out in a way that makes a person fear for their life. Generally, children and adolescents are tried in the juvenile court system. Now, the age at which children fall under the jurisdiction of the juvenile court varies from state to state. In Idaho, there is no minimum age, so a prosecutor could technically bring a 5-year-old into the juvenile court. In most states, the age at which a child falls under the jurisdiction of the juvenile court is 7 years, because children under the age of 7 are often seen as incapable of formulating criminal intent or mens rea. Right? They're still having issues thinking about cause and effect, right? And don't understand, right, how their don't understand their actions. Now, when we're looking at the older age group, right, and the age at which children are eligible to be moved from the juvenile court system to the criminal court system and treated as an adult, that varies from state to state. In Idaho, a juvenile can be tried as an adult for a serious misdemeanor or a felony if they are waived into the adult court system. There is a statutory waiver which covers offenses such as murder of any degree or attempted murder, robbery, rape, forcible sexual penetration by the use of a foreign object, mayhem, which is seriously injuring somebody. We're talking about cutting off an arm or a leg, or for example, cutting off somebody's ear. That's considered to be mayhem. And assault or battery with the intent to commit any of those other serious crimes. And a judge may also waive an individual into the criminal court after the age of 14. Mens rea. So I used the term mens rea before and argued that small children under the age of 7 are considered incapable of formulating mens rea. Right? Mens rea literally means guilty mind. It's Latin. And it refers to the ability to formulate criminal intent. And this has 4 elements. So you have to be acting purposefully. Right? So you have an underlying conscious objective, right, to act. Acting knowingly, right? You're certain that your conduct will cause a particular result. Acting recklessly, right? And here you're disregarding substantial or unjustified risks. So for example, when somebody commits a negligent manslaughter, right? They're driving while intoxicated and they hit and kill somebody. Right? You may not have intended to kill somebody, but you disregarded the really important risks that come when driving while intoxicated. Acting negligently. Here the defendant is not aware of the risk, but they should have known. Right? So generally, right, we understand that in the court system that adolescents, right, can formulate mens rea, right? But younger children, right, particularly under the age of 7, right, there's concern that they are not able to do so. So this has been a brief introduction to some of the terminology that you will be encountering at the beginning of the course.